Hey there, welcome to our AP Legal Zone podcast, brought to you by AP Lawyers. We are your top fix for all weekly law updates, including family, immigration, wills, and estates law. Just a friendly reminder, we are not your lawyers, and everything contained in this podcast is for entertainment purposes only and not to be construed as legal advice. Be sure to subscribe to our podcast so you can stay connected with any updates and get notified about our new episodes. Hi everyone, my name is Sherine Abdi.
And I'm Angela Princewill, and we're here to talk to you today about the matrimonial home and family residences. So if the name didn't make it clear enough, matrimonial home only applies to people that are married, and the family residence is essentially for common law spouses. But there's more to it, matrimonial home, right, Sherine?
Of course.
Yeah, so tell us a little bit more.
So a matrimonial home you can actually have more than one matrimonial home. However, you need to actually reside in that home as if you're using it, as a family residence. It has to be a property in Ontario. So you can, if you spend equal amounts of time within a property, let's just say in the city, and then you have a cottage, those two can actually qualify as the matrimonial home. Property outside of Ontario, unfortunately, would not qualify for our purposes. But the matrimonial home itself is pretty special because it carries several different rights. Angela, do you want to get into a little bit of those?
Yeah, I mean, there's the possessory rights, there's the, and by possessory rights, I mean that even if title is not in your name, you have a right to possess the home, right? So under normal circumstances, if I came to live in your home, for example, and I was an owner, you could just tell me to leave. Well, with the matrimonial home, you're not able to do that. Another special right is you cannot alienate a a matrimonial home without the consent of the other spouse, right? So those are actually the two most common. I don't know if I'm missing anything, but that's kind of what comes to top of mind when you're thinking about the matrimonial home. In terms of, there are special treatments, of course, in the context of equalization as well. So when we're calculating equalization, if you have an inheritance, for example, if you can trace the inheritance into a particular property, maybe an account or something, you could exclude that because under the Family Law Act, you're allowed to do so. However, if you put that money into a matrimonial home, unfortunately, you would not be able to exclude that portion of your inheritance or just any other sort of excluded property.
If you brought the home into the marriage, so if you owned the home at the date of marriage, you're not entitled to a date of marriage deduction. Yes. So as I think that's common misconception is, I brought this home into the marriage, it's mine. Or, at the very least, maybe he or she's only entitled to the increase. Unfortunately, it doesn't work that way.
Yes.
But yeah, it's very interesting.
I think that's one that I actually had a client many years ago tell me, like, why wouldn't anybody tell me this? She's like, Angela, nobody knows this though. And I'm like, I don't really know what we can do to help. So maybe we're doing something after all. But really, she was surprised. She's like, well, I understood that I would have whatever we built together. We would share whatever the increase was. But she said, but in her thinking, she's like, this is property that's been in my family for many years. And how does he just get the entire value, half the entire value of this home without any consideration that I brought it into the marriage, right? So that's something that
that's a tough pill to swallow. I think I had recently, a client had the matrimonial home, but he had owned it prior to the date of marriage, and she owned a home. Unfortunately, only his home was used as the matrimonial home, and he wasn't entitled to a deduction, and of course she was able to exclude her value of the property. So that was very unfair. But unfortunately, that's where you have to be careful. If you're going to be living in the matrimonial home, maybe buy a new home. Or
I was going to say that.
Buy a new home so you get the deduction.
So to make that a little bit clearer, if you have a matrimonial home that you owned on the date of marriage, you can sell it during the marriage and buy another home. And that way, if God forbid you have to be going through a separation years after, you get that date of marriage deduction. So if you're separating now, it doesn't matter, because a lot of people have this misconception of, I bought a house, we sold the home, I brought the home into the marriage, we sold it, and we bought this new house, we put the money straight in there, so it's a matrimonial home and I have to share it equally. That's wrong. Once you've sold that house, once it's not that same property that's the matrimonial home as of the date of separation, then you are entitled now to get a date of marriage deduction.
Yes.
So I hope we didn't confuse you there with that, but just understand that if the matrimonial home that you own on the date of separation is the home that you're unable to get that deduction, the date of marriage deduction for. But if you already sold that home and this is now a subsequent home, that special treatment doesn't apply to this home. You will be able to get a date of marriage deduction for it.
Yeah, so in short, it's the matrimonial home if it exists on the date of separation.
Exactly.
So that's the key feature. It has to exist.
When Sherine tells people, you can have more than one matrimonial home, I've actually had people say, well, we had the first matrimonial home that we sold and bought the second matrimonial home, and it doesn't really work that way. Like, those are no longer in existence. So those are not the first, second, and third. It would be the first, second, and third if you had a cottage that you went to every weekend in the summer and ordinarily occupied it as a family, not somewhere where you guys just, occasionally went to.
Yeah, or if one of you only occupied it, then that's not considerate of a family home. You're not using it as a family.
I'm actually dealing with a case like that where the other side thinks there's 3 matrimonial homes, despite the fact that, the 2 of my clients were ordinarily occupied by him alone 95% of the time. So spending 1 week at the cottage that the other person owns, it's going to be tough to call that a matrimonial home, because that's not how people ordinarily occupy their residences when my client is there, every other weekend, for example. So, but I mean, that's an existing matter and that's interesting, but I bring that up just to let you know that
not everything is a matrimonial home.
Yes, not every property you own is a matrimonial home.
And just for just for reference, there was also a recent case we were dealing with where they were living in a property. It was their matrimonial home, and just prior to separation, they had moved out and rented a property. Mm-hmm. So technically, they didn't occupy the home on the date of separation as their family resident, as their family residence in their matrimonial home. But honestly, in that circumstance, we would obviously make the argument that it would still qualify. So there's some leeway for, people intentionally doing something like that so that the home is not considered a matrimonial home.
Yes.
And just, for the purposes of equalization.
Exactly. So, having said that, let's jump into sort of the sale of the matrimonial home, right? So this is a huge one because most people's,
it's their significant asset.
Yeah.
They're probably the most significant asset that they have.
For most people, yes. Yeah. So, I mean, obviously there's usually conversations around, who buys, who out, and all of that kind of stuff. And sometimes that's just not possible. And the only way is sale. But let's approach this from 2 scenarios. So let's look at this from one where only one person owns title, and then we'll talk about where it's a joint title situation.
Rightfully so. So if let's keep it simple in a joint scenario, then both parties have the right to their share of the equity in that property. In determining the value of the property, they're entitled to the value of the property not only at the date of separation, but until it's sold. So if it takes a couple of years to sell, then they still get the value of that property after the fact as well. Mm-hmm. But if you want to buy out the other person's share, that's an option if you guys get appraisals. But ultimately, if one party doesn't agree, they can ask the court for a partition and sale of that property.
Oftentimes, people would, again, depending on what side of the conversation I'm on, but if I'm on the side of the party that's not in the home and is not trying to keep the home, it's always interesting when I see the other side insisting on an appraisal, and they're trying to convince me that it's correct because it was done by a reputable appraisal. And what the other side fails to understand is, I don't care. Like, they
don't have to.
I don't care. Like, I agree that the appraised value is correct. I agree that the appraisal is accurate and thorough and probably did a good job, and it's accurate, right? And you could take it to the banks and they could use it, and that's great. But we all know what fair market value. I mean, look at the real estate market in Toronto now.
Yeah.
Homes are going for $100,000, $200,000 above asking, and frankly, most of the asking price was already too high in my opinion anyway. Most of the homes, when you go in to appraise them, and this is, this is even happening we're hearing this from our mortgage broker partners and things like that, and they're advising caution, and they're caution to people, and they're saying people are buying homes for hundreds of thousands of dollars more than what the property is actually worth. So you get me an appraisal. That's great. It's true. That's exactly what the property is worth. But what a joint owner is entitled to is fair market value.
And the maximum amount they can. So if they want to go on the open market and get the highest amount they can, they have a right to do so.
Yes.
And one thing that I think we could talk about briefly, just since we're talking about jointly owned properties, is maybe occupational rent.
Okay, that's always an interesting one. So if you're holding back on selling the home and the other party has been moving to sell the home, what you're doing to that person essentially is depriving them of their capital, right? Because any equity in that home, they could be using it for something. If you both weren't occupying the home, they could have rented it out and received a fair market rent for that property. So that's why we would usually pursue occupational rent. And we would do that by looking at how much similar homes in the neighborhood could rent for, and would say, well, we're entitled to 50% of that because you need to pay them rent for occupying their home, and you're tying down their capital. And
especially when they're not living in that property, right?
So it is very reasonable. I mean, if both parties are living there, then you're enjoying the use of the property. But where one person is out, and I know that in the past, a lot of around this conversation always talked about ouster, and I didn't ask him to leave, and he just left and he abandoned the home. And if there's something that I would like to let people know, it's really not a thing in Ontario, this abandoning of the home thing. It's really not a thing. So I know many times, I'm not sure what jurisdiction this came from, but it really worries people a lot. Like they want to leave the home maybe just for peace sake, and they're like, am I abandoning?
Yeah, they just want to know that they were not they were forced out or whatever the case may be. But to be honest, it's not really a consideration when we're dealing with joint property.
It's your joint property, and if you leave the home, you're not abandoning it. If you're able to as a joint owner, much as you have the right to your capital in the home, so that means if you want to realize on your capital on a sale, you have a right to a timely sale, and the act makes it very clear that you will get that order. There's not a lot of discretion to the courts. Like it has to be something oppressive, vexatious, but it's a high threshold, right? The courts want to keep it simple. You own a property, you want to sell it, but when you now talk about somebody now depriving you of the use, of that capital, in fairness, it's not always that you would get that order from the court. Like I would think that we would see it more often.
And that may be because children are involved, there's other issues but honestly, in that case, like the court would weigh your interest against the capital that's sitting in the property and the other interest in your claims.
Yeah. I mean, so Sherine and I have this school of thought of, what, if the house is going to inevitably sell, let's get it sold, let's get issues done. And we want a clean break and we like to do it quickly. Mostly because just as humans, we feel that it's better for you if this relationship is over. We want to deal with the issues so everybody can move on with their lives and start what we hope would be another awesome phase of your life for you. So we don't want to tie things up in that sense. But if somebody is delaying in the sale of the home, the courts may not necessarily order a sale prior to trial, right? So, but if you're a joint owner, that's why we ask on the different act where it's clear that a joint owner can ask for a partition and sale of the home, and that's fine. But if you're not a joint owner and it's only one party that owns the home, it may not be as simple as this.
Yes. So it's important, I think, from the starting point, if you're the sole owner of that home, your spouse is not entitled to the value of that property after the date of separation. So you guys would have, well, really it'd be whoever owns the asset would have a responsibility to get an appraisal for the amount that it is at the date of separation. And that's the value that the other spouse is entitled to in the context of equalization. So it's not that they just get half of the equity that's available in the property. It's after taking into consideration all of the net value of their family property.
Yes, exactly. So I think what people often do is they'll deal with assets separately. It's really not advisable to do that because you may find yourself overpaying or being short paid. So you have to do it properly. The matrimonial home, while it has special treatment, you're not supposed to divide it separate from your other net family property. Just do it properly. It does. Oftentimes it may not make a difference, but there's times where you find that it
makes a significant difference. If someone has maybe significant amount of debt, maybe you won't even get a penny from that property, So it's unfortunate, but it does have to go in accordance with equalization, of course, subject to trust claims and things like that.
Yeah, so even if you're not entitled, but before I forget, there's something that's been hovering on my mind that I want to make sure that I point out, which is if you're the person that owns the home and the matter has, and the other side is trying to push for a sale so that it can, for whatever reason, you can dispute it. Or even if you're not the owner of the home and, you're the one that now has exclusive possession. I mean, when I say owner, I mean like titled owner. Now you have exclusive possession of the home. You can really ask that the matrimonial home not be dealt with until a trial. So that's one way that you can kind of delay things happening, because we can't rely in this case on the Partitions Act, for example, to get an immediate sale and things like that. Obviously, we can bring motions to deal with it. You can't hold back the sale of a home, for example, if one person can't afford to continue to pay the mortgage. If the titled owner can't afford to continue to maintain it, then it doesn't make sense to wait until trial, right? But generally, that's an argument that's available to you. But yeah, Sherine, you were going to say something earlier about the if you're a non-titled owner to the property, and that escaped my mind, but anyway, it will come back, because we were talking about how for equalization purposes the titled spouse is only entitled to division up until the date of separation. The non-titled spouse only gets it up until the date of separation. However, if for some reason,
subject to a trust claim.
Yes. So I'm trying to think of a circumstance that would qualify as a trust claim. So let's say you are not entitled, but you produced the down payment for the home, for example.
You produced the down payment and potentially maybe even renovation cost up until the date of the sale. That's actually a recent
And you've probably been contributing to the home even after the date of separation.
So you've contributed to the asset, maintained it. You were able to acquire it because of your contributions. That's where, it may be appropriate to proceed with a trust claim.
Yeah.
And if you want some more information on that, we have a whole episode on that, so please tune in.
Yeah, so go back and find that episode where we talk about trust claims. It's very that's what you would be doing. And trust claims applies a lot to common law spouses, but there's contexts where it applies to married spouses, and one of them would be a situation where you put down, maybe you both put down money on a home, and for whatever reason, it happens a lot with professionals, business owners, and things like that, where you don't have assets in your name because you're trying to keep yourself judgment proof. And now, you're separated and the other spouse has title to the matrimonial home and has refused to sell. And now 5 years later, your equity has been tied up, and now you're being told that you can only get the value of this home as of 2015. That's
especially
that's
if you
reasonable.
Separated and then you didn't consult with a lawyer, then you would really have no idea that the timing of which you're entitled to the value of that home stopped at the date of separation.
Yeah,
unless subject.
And even if you do know that, it still doesn't matter. If hey, you still have that claim. So yeah, you're still a lawyer, and I would still argue that the claim's available to you. But anyway, in terms of notice, so there's times where, things are moving very quickly. People are concerned that, about a party disposing of assets. And if you're not entitled to the matrimonial home, you might be concerned that the other side is going to make a move that would prejudice your position. And we want to let you know, all hope's not lost. You can register a designation of a matrimonial home on the property, and that puts every buyer on notice that it's a matrimonial home, and your signature would be required to sign off on any sale documents, transfer, that sort of thing.
Yeah, any refinancing, any loans. And I think that's the biggest concern is, especially when you're not on title, you don't know, you're not getting those mortgage statements, and you don't really know what's happening.
Yeah.
They could, forge your signature or say that it's not a matrimonial home.
I mean, if
sign
someone
that designation.
I don't know, Sherine, if we're looking at someone that's a fraudster, even with the designation of a matrimonial home, that doesn't stop that. So
it doesn't, but there is the fraudulent conveyances.
So if you're
that can actually remedy some of these issues if there is an issue of fraud.
Absolutely. But let's say if you're not dealing with a fraudster, but you just want to make sure that anyone that has taking an interest in this home, then you use the designation of a matrimonial home. If you're thinking that you're going to deal with a fraudster, I would highly suggest starting litigation and registering a certificate of pending litigation instead. Because while you may be able to go back and there's the fraudulent conveyances as Sherine was talking about, and that's a very good remedy for you. But if going in, you already have an idea that this person's fraudulent and may sign your signature despite you registering this designation, then put a certificate of pending litigation on there. Then that way nothing can happen until that certificate is vacated from title.
Yeah, just a precaution and extra protection.
Yeah. I would say that honestly, in most of our cases, we never have to do this. It's like a very small fraction of cases. So we don't want to give out the sense that you should run off and do this. It's a very few fraction of our cases that we've ever had to do this. Okay.
Yeah, so one last thing I want to know, which is also applicable to family residents, is after a sale of the home, we want to talk about maybe holding the funds in trust. So oftentimes, especially if it's jointly held, I mean, both parties need to consent for it to be released. Mm-hmm. But if you're going through a family law process and you have other claims such as support, sometimes it may be appropriate to hold the funds in trust. Mm-hmm. And only one party, so long as one party disagrees with the release of the funds, they would be held in trust. And typically you would have, your lawyer, if they're involved, just reach out to the real estate agent handling the closing. The real estate lawyer handling the closing that would go ahead and actually make sure that the funds are not dispersed.
Yes. Okay, so that's a good one. So let's talk about the family residence very quickly. And the only difference between the family residence, well, there's lots of differences, but the family residence is just where common law spouses reside. It's not a matrimonial home because they're not married. So that's difference number one. And that's what I was going to say is the only difference, but obviously that's incorrect because with the family residence, you don't have, you can, if you're the titled person, I guess you can sell, you can deal with your property however you please. You don't have the right of exclusive possession applying to those.
Yeah, you can change the locks, you can do things that you can't do with a matrimonial home. You can
deduct the value on the date before your common law spouse moved in. You don't even need to share the property with your common law spouse. You can argue that there's really no basis for...
Absent an agreement, there's no automatic right to share in the division of that property.
Yeah, exactly. So that's, whereas with a matrimonial home, you have all these special rights, both in terms of how it's dealt with when it's sold or even who gets to possess the home and things like that. And it automatically forms part of your equalization. Except, of course, you have a marriage contract. But if it's a family residence, it just goes by title, right? Whoever has title owns the home. Always subject to a trust claim, obviously, but the person has to make a claim to it. There's no automatic right. Whereas the family in a matrimonial home, there's almost that 50%. It's equalization right there. Family residence, there's no presumption for anything. And if you have title, technically it's your home. You can walk away with it free and clear. Mm-hmm. Are we going to, if you come to us and that's the situation, are we going to allow the other side do that to you? Obviously not. So, yeah.
I think that's so funny because I'll see people, consult with us and they're just, I'm not on title. I get it. But, he'll maybe give me, 20%. And I'm like, mm-hmm. let's look into this. Or, they're 50% owners, but they're saying, oh no, you're just on it for whatever purpose.
Yeah.
But I'm like, oh, you don't realize the power that you hold as a joint owner in that property. So
Exactly.
it's interesting.
We actually, Sherine, we had a matter together, and this was a matter where was at the Oshawa courts, and our client had put the family residence in both names as joint owners. And his spouse did not contribute anything to the down payment, did not contribute anything to the mortgage or maintenance of the home.
Renovations, anything.
And 2 years later, there's because he did put down a lot of money on the house, and so now there's hundreds of thousands of dollars. And as a joint
equity.
Yeah, an equity, and as a joint owner, she would have walked away with a few thousands of dollars after a 3-4 year relationship and contributing nothing.
Short relationship, yeah.
Yeah, so obviously we wouldn't let that happen, and we brought a trust claim because our position was you're holding your title as a resulting trust. I mean, there were all kinds of trust arguments that we made, but the main one was the resulting trust. We did also try to put in a constructive trust claim there, but the main thing was the resulting trust, the fact that she did not put any money down on the home. It wasn't an easy argument because when you put someone on title to the home, there's almost that presumption of a gift. So, but we were able to show that there were other reasons why he put her on title, and it was never his intention to gift it to her. So the lesson really is take title seriously. Yes. I think we can work around it. If title
doesn't reflect your actual intention, have a trust declaration or some agreement that outlines why that is, and not just agreement, just
not a verbal,
not like a written, whatever napkin.
Yes.
You really want to make sure that it's something serious and it's signed. And
yeah, if not, think about it seriously, because there's times where it could have gone the other way for our client, and he could have lost that. But thank God we were able to just intervene and make the right argument, and he was successful in that claim, which we think is the right thing to do. And honestly, there may be situations where we've also had cases, we've also had cases where during the relationship where things were good, the other side deliberately gifted monies to the other person that was put in the house, and the title reflected that, and that's what it was meant to be. And then you turn around years later and it's like, well, all of a sudden, because the relationship is not working out, you're going to make a trust claim. Again, we look at the facts of each situation, and we would obviously advise you of the pros and cons of your case. But if that's the case and someone actually intended to gift you the house, don't think that they could just make this resulting trust claim and just take your gift away. There's
a lot of factors that the court would consider whether or not there's even merit to that, to be honest.
Exactly.
So in addition to that, the sale would go, again, like if you're the sole title holder, you would ask for a sale of the home. Well, you don't really ask.
You don't have I would proceed. Yeah, you proceed to sell. Now, you may have a conversation about it if there's children involved, right? Because now you can't just have them kicked out on the street, and you have to make sure that, somehow they have a place with the other partner. Even if you're the primary care parent, it just the optics of it when there's children involved might not be the greatest.
Changes everything, yes.
Yeah. So, but if it's a family residence, you also, and it's jointly owned, then you also have the right to ask for partition and sale, just like you will in the matrimonial home. And what else?
An occupational rent.
Yeah, that would. I mean, yeah.
And a jointly
but
owned
I don't
property.
even know how it would. Well, I mean, it could apply by default, but really. Yeah, if someone's just occupying or if it's jointly owned, and even if it's not jointly owned, then that's even more annoying because it's your asset. You left to keep the peace, and now someone's staying there and just wouldn't leave. So yes, you do need to get some sort of recourse. Oh, something we should mention actually. There's times where, for whatever reason, the matrimonial home or the family home residence division of the equity, whether it's by sale or whatever, don't go smoothly. And I think we've touched on this before as well. There's damages claims that can be brought, okay?
It's our favorite.
So because sometimes people out of anger might
hold on to the property, refuse to sell
destroy the
it.
property, make you lose value. Like right now, real estate is really high. Real estate values are high, and
so you can seek a claim for any monetary loss. So let's say even someone failed to accept an offer to purchase, and you never got an offer similar to that. They offer 2.2, and the highest next offer that you get, and you sell it for the next couple months is 1.8. Then you could ask to sue them for half the shortfall because of their refusal. You lost out on a very good offer.
Exactly. Yeah, exactly. So that's something to keep in mind. So if you're selling, if you're joint owners, just be very mindful. And, if you're going to be selling the place, do things in a timely manner so that we're not having to look at whatever damages. And I mean, it's no fun. No one's wanting to quantify the damages and do all of that. So it's better when people do things in a smooth manner. Even if you're the sole titled owner in the matrimonial home, obviously, that's not, it doesn't really matter as much, except that you can keep the value of your home as of the date of separation. But if it's a family residence, just remember that you don't have the same automatic rights. Whoever has title has it, subject to any trust claims that you can make. I think that's
I think one more thing is the certificate of pending litigation is also applicable to family residents.
Oh yes, that's true.
You can, if you believe that, just want to secure, if you want to go, if you're in litigation, first of all, and you have a fear that you're the non-titled spouse and, the other partner is going to just sell your interest, encumber the property, whatever it is, refinance, you want to you can actually pursue a certificate of pending litigation as well.
Exactly. Yeah, that's a good point to note. Okay, so that's it for today. And we will join you next time to record another fascinating family law topic. Take care. Bye for now.
Bye.
Thanks for listening and joining us in the AP Legal Zone. We hope you enjoyed this episode. You can find more episodes by searching AP Legal Zone on anywhere you watch podcasts. Be sure to subscribe to our podcast today so you can stay connected with any updates and get notified about any new episodes.